Hi, Patrick Conroy here with Chapter 4, Conflicts of Interest, the Duty of Loyalty. Hopefully we can get this done in just one presentation. Okay, the purpose of this chapter is to introduce conflicts of interest, to recognize a conflict of interest issue when it presents itself, and find the law of conflicts in your own states, and finally explore ideas for avoiding potential conflicts and for dealing with existing conflicts. Keep in mind, with our clients, we have a duty of loyalty, and that's a promise to always act in the client's best interest. And always means always. The promise made to each client never ends. You can carry all past promises with you from job to job. That's what I mean by always. So you have the duty of confidentiality, keep clients' information secrets. And as we've said, this promise never made, and you can carry all past promises from job to job. Fiduciary duty. Okay, you'll hear this a lot in the law profession. In many instances, lawyers and paralegals have what's called a fiduciary duty. And this includes loyalty, confidentiality, complete disclosure, accounting. So the fiduciary is a person who acts on behalf of another and in the best interest of the other. So it's always their best interest. You are a fiduciary. When you enter the field of law, you agree to take on the role of fiduciary to every client. Duty of confidentiality, duty of loyalty, and duty to represent them in their best interest. So even if you're going to sell them, buy a car from them, you really shouldn't, because you have to then somehow make it in their best interest to sell you the car, which might not be in your best interest because you want a cheap car. Inexpensive car. How is conflict created? By the continuing obligation to preserve the confidence of past and current contacts. So the duty of loyalty is owed to each and every client. So, it's very easy when two clients come in and they're on opposing sides of a matter at hand. That's easy. You can't do both. But you also have to look at your past clients to see if maybe one of their, they might be part of a conflict with a new client that's just come in, even if it was years ago. So don't represent a client if that representation involves a conflict of interest. A conflict of interest exists in the representation of one client. If it's directly adverse to another client, those are usually easier. This can be the tricky part. There is a risk that the representation of one client will be limited by your responsibilities to another client, a former client, or your own personal interest. Now, they're talking about Rule 1.7. It's an ABA model statute regarding conflict of interest. You can look it up, and I'll probably have you research Louisiana version. Concurrent representation conflicts. Clearly, if A is suing B, you can't represent both. You also cannot represent B for any other needs B has. Even if it's not related to this lawsuit, you must be loyal to A, and your duty of loyalty to A never ends. Once you have a client confidential information, you can never represent anyone against A. The amount of confidential information you have about A is related to what kind of work and how much work you did on A's legal matter. So once you've represented somebody, you can't then represent somebody else suing that person. Substantially related test. It is okay to switch loyalties as long as the previous representation is not substantially related to the present one. The small or tangential involvement in a case may not create a conflict. The question is, how much confidential information was available to the conflict employee? So how much did you know about them? It's not the actual receipt of the information, it's how much was available. So if I could have read these things, it's going to be assumed that I did read them. Now, a conflict can lead to disqualification. Okay, you have A's confidential information, and you change job, and you take A's info with you. You should not take a job with a firm that has any occasion to use A's info against him. A court will assume that you've told or will tell everyone in your firm all of A's confidences. There's no conflict if your firm also represents A. That's clear, that's easy. Or if there's no conflict exists if you move to a firm that isn't representing anyone against A. How do you avoid conflicts? You keep track of each client in case you work. Keep track of what you did on each case and keep written records, because you won't remember things 2 years from now that you worked on. Now, freelance paralegals, it's especially difficult for them because they don't have someone supervising them, telling them, we can't work on this. So they have to be vigilant about keeping track of conflict information. Client name or the matter name, case number, date of work, extent of work, and work product produced. So you can tell any lawyer that tries to hire you, hey, conflict of interest, blank, 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 without revealing any confidential information. Okay, could be a conflict from your personal life too. Any transaction with clients creates conflict. Being a witness in a case creates conflict. Gifts from clients create conflict. Financial interest in the case creates a conflict. Having an intimate relationship with a client creates conflict. There are specific rules about romantic involvement with the client. If you are already in a relationship, then that's okay. But if you get into it while representing them, that's a no-no. And that simply because there could be a breakup. And then how will you still be zealously representing that person that you just had a nasty breakup with? So, wait till they're not your client anymore. Sometimes there's concurrent representation issues when you're representing the seller and the purchaser, or the husband, the wife, the debtor, creditor, and the joint representative criminal defendants. Some of these you can still do if you make it clear that you're representing both sides and that they are free to seek outside counsel, and there's nothing in conflict. But it can turn out nasty, in which case you just have to have one of them get another lawyer. You might be representing a husband and wife on a business matter, and then they get in a fight and search a divorce, and everything turns nasty. So you have to say the wife has to get, or the husband has to get their own lawyer. Okay, representation of corporations. A corporation is a legal entity. Representation of the corporation is not representation of the individuals who work for or run the entity, because the conflict will come from the confidences of the corporation. So, Smith is head of corporate X. You're representing corporate X on all sorts of issues. Somebody sues the guy personally in a matter like a property line dispute, that would be okay, because they're two really different things. And the corporation is one entity, and its CEO or whatever is a different entity. Unresolved conflicts of interest will cause you to be disqualified from a case. If you are disqualified due to a conflict, it's likely the entire firm will be disqualified. And the other side, often, they might put a motion to disqualify just to be tactical, because it's going to run up their opposing side's cost if they have to switch lawyers. They're expensive and time-consuming. If the client has to hire a new law firm because of your conflict, it will be bad for you. And they could, sue you for malpractice or something like that. An alternative is which is called the Chinese wall. So you're working for a firm and you've worked with them for 2 years. Then someone is suing someone you represented at your old firm. What they have to do is they have to build what's called the ethical wall or Chinese wall. The wall must be built when the conflict begins, and the conflicted person must be completely walled off from the legal team on the conflict case. So there's no sharing of information. Must prevent contact with the files, experts, witnesses, etc. And not all states recognize these. Some states allow walls for former government personnel only. That's when someone who worked for the government goes into the private practice, and then there's a client that wants to sue the government. So the Chinese wall is built around that person. Good resumes prevent conflicts. If the future employer sees where you've worked in the cases, they can evaluate the possibilities of conflicts. There is a possibility of a waiver to eliminate a conflict, in which case that's if you get the former client to sign a waiver. They're not going to be eager to do that because they might have told you things that they really don't want anyone to know. A contract between you and the former client guarantees that you will not reveal any of his confidential information. So you still can't reveal it, but it's a question of how much they trust you not to reveal it. When a conflict walks in the door, immediately tell your supervising attorney, erect the ethical wall. The lawyer still has to explain the conflict to the new client, and the lawyer informs opposing counsel if any. And you try to get an informed, express written waiver from the former client. Maybe yes, maybe no. So that wraps up this chapter. Good luck, and I'll be posting more videos for it.